राष्ट्रीय न्यायिक सेवा प्राधिकरण
न्यायालयातल्या कारवाई खातीर बरो वकील मेळून दिता.
वेळार योग्य कायद्या खालची मदत आणि सल्लो दिता.
लोक अदालत द्वारा चढ काळच्या केसीक बेगीन सोपयता.
आणि ते बी सामके मोफत.
राष्ट्रीय न्यायिक सेवा प्राधिकरण बेस बरो न्याय बेस बरो समाज.
अधिक माहिती खातीर लागच्या न्यायालयातल्या न्यायिक सेवा प्राधिकरण कार्यालया लागी संपर्क करा
वा टोल फ्री नंबर 151000 चेर फोन करा.
Hello everyone, I welcome you to the virtual Juridicare series organized by the Goa State Legal Service Authority. I am Advocate Vidati Shetty, your host for today's session. It is an honor to introduce today's speaker, Advocate Susan Linhares Costa, who has been practicing in these courts of Goa for almost 2 decades. Well, Advocate Susan Linhares Costa is a standing counsel for the Income Tax Department. She is also an additional government advocate for the state of Goa and a special public prosecutor under the Drugs and Cosmetic Act. Today she will be speaking on this topic, income tax under Portuguese Civil Code 1860. After Goa got its independence, all pre-1961 laws of India were not necessarily applicable to the state of Goa automatically, but they had to be specifically extended. This section of Portuguese Civil Code till date has been retained in the Income Tax Act, and it is only applicable to the state of Goa and the Union Territories of Dadar and Nagar Haveli as well as Daman and Diu. Welcome Advocate Susan. Your viewers are waiting to get enlightened on this interesting topic.
Hello everyone, a warm welcome to you all. Today's topic is income tax under the Portuguese Civil Code. Income tax is a very vast subject. The Act itself runs into 89 sections, subsections and over 100 rules. But today I'm not going to be dealing with all that. Today's topic is limited to section 5A, which is applicable to couples married under the Portuguese Civil Code in Goa. I will also be dealing with certain deductions which are permissible while computing the total income of an individual. Now, section 5A is relevant to all of us in Goa married under the Portuguese Civil Code and governed by the system of community of property, which is also known as Comunhão de Bens under the Portuguese Civil Code. This section is enforced in the state of Goa, in the Union Territories of Dadra and Nagar Haveli, and Daman and Diu. This section 5A deals with apportionment of income between spouses under the Portuguese Civil Code. Now, according to this law under the Portuguese Civil Code, when a marriage takes place, the properties of the spouses gets blended and each spouse becomes a 50% shareholder in the combined property. Each spouse is entitled to 50% of the income of the other spouse. This law under the Portuguese Civil Code is not applicable to the rest of India, and therefore it was posing problems at the time of assessment before the Income Tax Department under the Income Tax Act. Now, there were doubts whether the income was to be assessed in the hands of the community of the property or in the hands of the husband and wife separately. Therefore, the Act was amended and Section 5A was inserted by the Finance Act of 1994 with effect from the assessment year 1963-64. Now, this set to rest the controversy which was faced by the Income Tax Department. Now, this section provides that all income from all sources except salary should be apportioned equally between the husband and the wife, and such income shall not be assessed as income of the communion of the property. Now, the income so apportioned is to be included separately in the total income of the husband and the wife. The remaining provisions of the Income Tax Act will apply as applicable to the rest of India. Now, income which falls under the head salaries or salary of the husband or the wife, as the case may be, is to be included in the total income of the spouse who has earned it. Salary income continues to be assessed in the hands of the spouse who has earned it, and it does not get apportioned by 50% in the hands of the other spouse. An individual whose taxable income is more than 5 lakhs and bank interest more than 10,000 rupees is required to file returns. husband and wife whose total income is apportioned and whose income thereafter exceeds 5 lakhs is required to file returns. They can claim deductions under Section 6A of the Income Tax Act and also claim rebate under Section 7A of the Income Tax Act separately. Now, people are generally under the impression that in case their income does not exceed 5 lakhs, they are not required to pay tax. This is because for normal income, the tax rate between 2.5 lakhs and 5 lakhs is 5%. Now, a tax liability of 5% on 2.5 lakhs comes to exactly 12,500, which is the rebate available to an individual. Now, in case your income comprises of income which is taxed at a higher rate or at a higher slab, that is for short-term capital gains, it is 15%, and long-term capital gains, it is 20%, then in such cases, then even if the income is less than 5 lakhs, then you are still required to pay tax at the slab rate. Now, the basic exemption of 2.5 lakhs has not changed for some time now, because the government does not want the people to go out of the tax net and be exempted from filing income tax returns. But at the same time, the successive governments have proposed rebate for taxes for taxpayers up to a certain income limit. Presently, the rebate for tax is available for those whose income does not exceed 5 lakhs. This rebate is under Section 87A. Now, an individual who is a resident of India for income tax purpose is entitled to claim rebate up to 12,500 against his tax liability, and if the income does not exceed 5 lakhs. Now, if your entitlement to claim the rebate under Section 87 gets totally lost once the income exceeds the limit of 5 lakhs. Now, coming to deductions which can be claimed by an individual while computing the total income are available under Chapter 6A of the Income Tax Act. In fact, Section 80G onwards deals with all the deductions which can be claimed by an individual while computing the total income. Now, under Section 80C, if you have a LIC policy, the premium can be claimed as a deduction. Deductions can also be made if you are earning a pension. If you're getting a pension, you can claim that as a deduction. Contributions made towards public provident fund or the provident fund set up by the central government. Subscriptions made to any government savings certificate, mutual funds, debentures, shares can also be claimed as a deduction. Subscription to deposit scheme of the public sector company which is engaged in providing long-term finance for construction or purchase of houses can be claimed as a deduction. Tuition fees at the stage of admission to any university, college or school or any other educational institution within India can be claimed as a deduction. Installments or part payments for the construction or purchase of residential house property can be claimed as a deduction. A term deposit for a fixed term of not less than 5 years with a scheduled bank can be claimed as a deduction. Subscriptions to bonds issued by the National Bank for Agricultural and Rural Development, as the central government may notify, can be claimed as a deduction. Account under the Senior Citizens Savings Scheme rules can also be claimed as a deduction. A 5-year term deposit in the account under the Post Office time rules can also be claimed as a deduction. Then if you have an individual or a dependent which has a disability, the expenses incurred towards medical treatment, training, rehabilitation of the dependent which is disabled can also be claimed as a deduction. Now, Section 80DD also provides for deductions in respect of medical treatment which you have undergone. There are deductions in respect of interest on loans taken for higher education with effect from 1995-96 individuals pursuing higher education. A deduction with regard to repayment of loan taken from any financial institution or approved charitable institution with effect from 2001-2002. The quantum of maximum deduction was increased from 25,000 to 40,000. Deductions also are available in respect of interest on loans taken for residential house property. Now, deductions in respect of donations to certain funds and charitable institutions. Now, the funds, if you are contributing to a fund which is of a national interest, it should be a National Defense Fund or Prime Minister's National Relief Fund or National Children's Fund. The fund should be in the interest of the nation. Now, donations made by you towards charitable institutions have to be towards renovation or repair of a temple, mosque, or a church, and or any other place notified by the central government to be of historic, archaeological, or artistic importance, or it be a place of worship renowned throughout the state or states. Now, deductions are also allowed in respect of rents paid for an individual accommodation, donations in respect of scientific research or rural development contributions given by the company or individual to political parties, professional income of authors of textbooks in Indian language, royalty, income, interest, or deposits in saving accounts with respect to these books are also deductions which are permissible under the Income Tax Act. Now, most of these deductions come with a rider or a proviso which gives the assessing officer or the income tax department the upper hand. Now, he has to be satisfied that your deduction does not come under the proviso or you are not precluded from claiming these deductions. Therefore, when filing the return of income and claiming deductions, one has to be very cautious that you do not fall under the proviso. Now, it is always advisable to disclose all your income correctly at the time of filing your original income returns and claim the deductions, if any, because if you fail to disclose your income correctly and you have wrongly availed of certain deductions, and it comes to the knowledge of the income tax department, then they can reopen your assessment even after 4 years by giving you a notice under section 148. Now, willful evasion of tax is a perennial problem of the Indian tax system. Willful tax evasion can land you in jail because the Income Tax Act provides for penal provisions which can land you in jail if the Income Tax Department finds out that you have willfully not disclosed your income to the Income Tax Department and have evaded payment of tax. Now, the penal provision provides for imprisonment, which can be up from 3 months to up to 12 years with fine. So, my advice to you all is file your income tax returns on time, avail the deductions which are available under the Income Tax Act, and be within the law. I hope that this talk will help you in availing the maximum number of deductions and will help you also to file your returns on time. Thank you.
Thank you, Advocate Susan Linhares Costa, for the valuable information you have shared in today's session. I request all the viewers to kindly share, like and subscribe the channel. Thank you.
एहसास न्याय का सबके लिए, आकाश न्याय का सबके लिए, उल्लास न्याय का सबके लिए, विश्वास न्याय का सबके लिए।